Thank you very much. Can you all take your seats?
Recording in
physically here
progress.
and in the virtual platform. Good morning, everybody else. Welcome to the members at M46 and members on the virtual platform. Morning to the public protector, as well as her legal team led by advocates Pofu and Chabalala. Welcome to our evidence leaders, Advocate Bauer and Advocate Mayosi. Welcome to the media, our support staff, and last but not least, welcome and thank you for joining us, members of the public, as you watch these proceedings with interest in all of your platforms, YouTube and 418. We watch you too, in terms of the things you raise and say. Today is the 4th of August, 2022. It's the next day, and we have the next witness. I'm now going to take this opportunity to invite I'll start with Advocate Bauer, and then I'll go to Ms. Fatima Ibrahim.
Good morning, Chair. Good morning, everybody. We're calling this morning Mr. Baldwin Mashunzi.
Thank you. Has he logged on? My timelines for the day remain as they were for the last 2 days. That you will start now from 10 evidence leaders up to about 12, and from there the team of the public protector for cross-examination, and we'll end with the members. I'm just waiting to check if Mr. Baldwin has joined the platform. Tembigosi, you will indicate when he's on the platform, because the start is with him. Just to make sure that those who are on the virtual, we can hear them. Advocate Mpofu, can you hear us?
Yes, sir. We can hear you clearly, Chair, but my hand is up.
Thank you. Good morning.
Good morning, Chair.
Let me just check if, can you hear us, Honorable Meldo?
Yes, Chairperson, good morning. I can hear you all very clearly, and my hand is not up.
I see that. Thank you very much. Whilst I'm waiting for Mr. Nshunzi, I will go to the black hand that I see there.
Okay, Chairperson, sorry, my hand is suddenly lightened up here. Chair, I just wanted to address an issue which might be conveniently addressed even before you swear in this witness. We want to register an objection as to the relevance of this witness, Chair. And as you know, in terms of the directives, it's your decision on relevance. And without wanting to sound like a broken record, as you know, we've objected to the directives. But even on the basis of the directives as they stand, it is our respectful submission that this particular witness and even some of the other so-called disgruntled employees is going to give evidence which is not relevant to the motion that is before you. And all we want is just a ruling from you. We obviously will have to go along with whatever ruling you give. If then you can just give me just a few minutes to address why we say this witness is not relevant, Chair. Our starting point, Chairperson, is that as you know, relevance must be gauged against the business that is in front of you. Now, we have a problem, of course, again, without revisiting that issue, in the sense that, in our view, the committee should be busying itself with those matters that I'm sure you'll understand it better, Chair, that would have gone through the eye of the needle, which is the independent panel. We've put our views on that. There's been a ruling against us on that. That is a matter that we don't want to re-argue now. The only reason I'm mentioning it is to make the following point, that in our view, even on the irrational widened scope of this inquiry, the evidence that is about to be presented is completely irrelevant. Or rather, maybe we should be posing the question to the evidence leaders, since they are the people who have called the witness, as to what is the relevance of this evidence. And if it is relevant, to which issue is it relevant and why? And Chair, we're doing this not frivolously. We're doing it to demonstrate that this committee should not be turned into some complaints office for people who might have gripes about this or the other in some office in one of the provinces or even at head office, because that's not the business of this committee. It's not even the business of the Portfolio Committee on Justice, to which we report, or to which the public protector normally accounts, let alone this one, which is an ad hoc committee specially constituted for a particular purpose. So its purpose is confined. In this case, it's confined by the motion. Because we've had a fair number of these so-called disgruntled employees. That's fine insofar as their evidence might be relevant to one of the issues. It must be remembered, Chair, that the core of the complaints around which the so-called impeachment charges are based, as summarized also even by the independent panel, revolves around charges of misconduct, which is defined in the rules, or incompetence, which is also defined in the rules, based mainly on the confirmation or refutal of the adverse comments made by judges in four main judgments: the CX judgment, the Freede judgment, the Financial Services Conduct judgment, and of course the CR17 Busasa judgment. It was correctly summarized that there's an exception to that, which was the evidence of Mr. Samuel, which I've gone through with the committee before, and these allegations of so-called victimization and harassment and all that associated with the internal staff. So this thing has now turned into, as I say, a complaints office, away from its core issues, which are the comments that are contained in the judgments. And this witness in particular and I'm sure all the members have read his statement, does not even approximate to deal with the issues that are raised in the motion. Or at least, as I say, if we are wrong, then we pose that as a question. And we would like to be told, or the committee to be told, what would be the relevance of hearing from someone who says, oh, well, you know, I was transferred from one department to another. So what? How is that got to do? What has that got to do with whether or not the Advocate Mkhwebane is guilty of the charges as defined in the rules? In other words, let's assume everything is going to say is true. How does it? What value does it add to the determination of the question in front of you? Because otherwise we can have a long list of everyone who says, no, I was denied leave. This one says, no, I was beaten up, but no, it was not followed up. But until that can be traced or connected to the motion, then it might be interesting, you know, to listen to. But the question, is it relevant? And we say it is not. And if this process really costs 1 million rand a day.
Thank you. I think you have covered. I've heard you very well. If perhaps you can now wrap up, Advocate Mpofu.
Okay, Chair. No, that's fine, Chair. I'm almost done. Yeah. No, the only point I wanted to make is that the issue of relevance is not just one that floats in the air. It is related to the speed with which this process has to be finalized, because by its nature, it is one that is depriving the public protector of her, her ability to continue working. But that is not even the most important thing. The most important thing is that the longer this thing goes, the more the public is deprived of its public protector. And the point I was making, Chair, when you intervened was, if it is true that this process costs 1 million rand a day, that for public representatives should be reason enough to ensure that we don't sit here and spend more days on unnecessary evidence that does not going to add any value to the determination of the question. Thank you, Chair.
Thank you, Advocate Mpofu. Before I respond and make a ruling, I'll hear quickly Advocate Bauer.
I'm fully in agreement with Mr. Mpofu that only evidence relevant to determining the veracity of the grounds as set out in the motion should be put before the committee. Where evidence is put before the committee that is not so relevant to the grounds, the committee must disregard that evidence. We have been going back and forth of the extent to which the evidence leaders have assisted witnesses in compiling the affidavits. We don't always have sole say of what the deponent wants to put into the affidavit. We have refrained ourselves from demanding X, Y, Z being included or excluded from an affidavit. So we assist witnesses. This is one of, we also have witnesses who have come forward before to participate in the inquiry, and witnesses who are integral in the part of the PP's office whom we have asked to assist the committee. There are at least 3 aspects in which this witnesses' evidence bears relevance. In the context of the CX matter, Mr. Moodley was identified as one of the people who had handed over the piece of paper containing the amendment of the Constitution to the public protector in a meeting. And he is personally known to this witness as somebody who works in the computer-related field and not an economics-related field, which is in his affidavit. So in our view, when that is relayed to us, that bears relevance on the motion before this committee. He is also one of the people whose computers was removed and whether his documentation was returned to him intact or not bears relevance on corroborating what Mr. Mpofu calls the disgruntled witnesses or not. This is not a witness that's disgruntled. He had certain labor issues which he took issue with his employer. He remains within the public protector's employ. In fact, he's been promoted up the ranks to a better position than what he was in when these events happened to him. And there's no means that the affidavit in which his personal encounters have been represented in anything other than what it was. So when we put him forward as a witness, it was because in the contents of his affidavit, there were issues that we thought bore relevance.
Okay, thank you, Advocate Bauer. Having listened to both of you, I now
Chair,
just want.
I have to, sorry, Chair, I have a right to reply.
Yeah, but that right can only be given by the chair.
Yes, I'm asking for it. I'm not saying I'm taking it. I'm asking for it.
Okay, let me hear you, Advocate Mpofu.
Thank you, Chair. Yeah, I'll be very brief. Yeah, Chair, I accept what my learned friend says. She says, really, on relevance, computers were removed and corroborating something. Let's assume again that is so. The point I'm making is that then, so what? What is the relevance of this particular evidence to the motion that is in front of you? And Chair, just for your assistance, what I'm doing is if you go to paragraph 8 of your directive, that is what is happening now. Paragraph 8 says, and I'll read it out, 8.1, only questions, evidence, and submissions relevant to the issue of incompetence and or misconduct as alleged in the motion shall be asked, led, or made during oral hearings of the committee. Okay, so it's very simple. Only those questions can be led in evidence or asked, or I think everyone agrees with that as the premise. Then 8.2 says, in the event that there's any objection as to relevance of evidence, which is what I'm doing now, the chairperson shall make an immediate determination as to the admissibility thereof. The chairperson may make a provisional determination that the question and or evidence submission is relevant, and once the committee has heard the evidence in full and closing arguments, if any, committee in its deliberation may make a final determination regarding such evidence or submission and indicate whether in its report whether such was taken into account in the making of its recommendation to the assembly. That's all. That's your directive with which we disagree, but that's what it says. So we're just invoking that paragraph, and two things can then happen. You can make it a determination, which I suspect you are about to do, and then we will deal with the matter according to your determination. But there must be a determination. That's what the directive says. Sorry, just 1 second, Chair. Yes, it says you may also make a provisional determination, an immediate determination, or a provisional determination. So those are the options. But on the merits of the objection, we simply say that even on what the evidence leaders have said, there's been no mention of which of the charges this relates to, and in what way is it going to assist one way or the other, the determination of that charge. That's what we were expecting in terms of relevance, because they are the ones, of course, they might have spoken to 100 people, but they are the ones who determine, the evidence leaders, which 20 or 25 of those, and that they can only do on the basis of the relevance. If the other 70 people are talking about irrelevant things, then they cut them out. So to put it simplistically, we want to know on what basis was this person determined to be going to help this committee. Thank you, Chairperson.
Well, thank you very much, Advocate Mpofu, for raising those issues. Just to, as I summarize and make a ruling, 2 issues to raise. Let me start with a quicker one so that I get it out of the way. And you would have referred to it. It was not started by you. It was a throwaway comment, I think, by one of the members. I don't know where it comes from, this 1 million issue. And I'm saying you referred to it in saying, if that is true, you have a concern. So I want to dispel that. No basis for that throwaway comment which was made about this 1 million thing that we're spending here every day. But further, would have said at the very beginning of this process, especially when we determined our terms of reference, that this is a priceless process. This is about us enhancing democracy. This is a constitutional process by the National Assembly that we've got to do this work, pioneering work, and the focus is to do it properly, both in terms of process and the outcome of it. And so nobody is ever just going to throw a figure to us by way of distracting us from doing this work. And so I'm saying, firstly, about the throwaway comment, it has no basis. It would have been thrown here because the fact that it gets repeated doesn't mean that we're dealing with a fact here. So I want to start with that issue first. Secondly, as I make the ruling and determination, I appreciate your consistency, because at the beginning of this inquiry, as we dealt with the directives, you would have raised some of the issues in relation to whether, and I remember the clause about whether we must entertain any charge that would have been defined in the independent panel report as not relevant. You raise that issue up front. I cannot falter you on that. That's the consistency I'm referring to. We, however, as a committee, hold a different view, and I hope you accept that in terms of that issue. I think you have helped me already, but I want to, as I make the ruling, to refer to all of you to both Directive 3.2 and 8.2 that you have pointed out. And I'll read 3.2 because you've had us reading 8.2. 3.2 says, only evidence relevant to determining the veracity of the grounds of incompetence and misconduct set out in the motion should be put before the committee, and any evidence not so relevant that may be placed before the committee will be disregarded. The essence of what this says, it says we're not going to bar or stop any evidence being placed here. But as we go through this and in our deliberations and conclusions, we can disregard. This is the key issue. Disregard anything that would have seen as irrelevant in this. And I think when you read 8.2 reinforces that in saying that from the leading of evidence, your cross-examination, the interaction by members, we will be able to determine as we get into deliberations whether what would have been placed here, because it's very possible that up to so far there's something that would have been placed that might not be relevant to what we want to conclude on. So in that regard, I do want to immediately say we would proceed with this witness in line with what I've just placed that will, as we start with this witness, going to be determining that issue of relevance in our deliberations. But I thank you that you placed this on record, and nobody must falter you for doing that. Thank you very much, Advocate Mpofu. I now proceed
Chair,
to Ms. Fatima Ibrahim.
Chairperson,
Ms. Fatima Ibrahim.
Chair.
Yes, Advocate Mpofu.
Yeah, please indulge me, Chair, just for 2 minutes. I'm not questioning your ruling. It's noted, and I accept that it is your ruling. I just want to say this, so that we don't have to do this with every irrelevant witness that comes. Otherwise, we'll be wasting time once again. So if you give me the 2 minutes, it will save us many minutes in the future. This is all I want to place on record, Chair, and I don't need any ruling on it. Maybe we'll even give you a written submission or a letter for the consideration of the committee at your next meeting. We don't agree with your reading of 3.2 and 8. And let me explain very briefly. Yes, you're quite right. It says that the only evidence that is relevant to the motion should be put before the committee. And that's what we say, that's what we're trying to prevent. And of course, as you correctly point out, some evidence might slip through that is irrelevant and it might have to be sifted out. But that can be the primary position. That's the default position, is that you must prevent irrelevant evidence. If it managed to slip through, well, then it will be disregarded. So it can be that I can call somebody here who's going to tell us about a football match between Orlando Pirates and Kaizer Chiefs for 2 days. And then you say, well, I'm going to listen to it because we can disregard it at the end. That would be the most wasteful exercise or inefficient use of money. Whether it is $1 million or $500,000 or $250,000 is irrelevant. It's still the money of the taxpayers, and it should not be wasted in vain. And therefore, the issue is we have to try and prevent irrelevant evidence. If we can't, because life doesn't work in straight lines, then it will be disregarded. But we can't start on the basis that we'll allow anything, because we know that 3.2 says that we'll disregard it at the end. I just want to place that on record.
Thank you.
Fundamentally.
Thank you, Advocate Mpofu. I am making a provisional ruling that this is relevant, and we will proceed.
Thank you.
Miss, before that, I see your hand, Honorable Mulder.
Thank you, Chairperson. Good morning, colleagues. Now, I just think we should also have clarity that it's up to the committee to decide whether we regard or disregard the evidence. The committee will regard and decide in the end whether the evidence would be relevant or not. And the second point I would like to make is that we are all concerned about the time and the cost, and seeing that Advocate Mpofu believes that the witness and the evidence is irrelevant, we will save them time on the cross-examination, which I think is positive. Thank you, sir.
Thank you. I see 3 more hands, but I've already made the ruling. I hope those hands are making comment in that regard. I recognize Honorable Heron.
Thank you, Chair. Yeah, no, this is not to contest the ruling, but really to support the idea that the evidence leaders and Advocate Mpofu perhaps agree some of the evidence. I haven't seen much sign of them meeting and agreeing what is not in dispute. You will recall 2 or 3 days ago, I asked a witness, my first question was, what are you doing here? I mean, we spent 10 hours with one witness, in my view, whose relevance is questionable. And are we going to do the same thing today? I'm not challenging a ruling, but I think we do have to look for relevance. And it would help, if it hasn't already happened, if the 2 legal teams could agree what evidence doesn't need to be led because it's agreed.
Thank you, Honorable Heron. Honorable Mauter.
No, thank you very much, Chair. Mine will be very quick. Chair, you mentioned, and you said it's been mentioned somewhere else, the issue of 1 million. Now, is it possible for you to give us an indication of how much we are spending as the committee on a daily basis, but also the projection of how much it will cost us? And we've got a program before us, and that program should then be costed so that the public can also know that Section 194 committee is planning to spend this much money on this process. If you can do that for us, Chair. Maybe not now, but maybe in the next meeting, you can just give us that highlight of how much we're spending. Thank you.
Thank you, Honorable Mautwe. In our own in-house committee meeting, we will do that. Thank you. I now, having ruled that there's a provisional relevance to this point, I want to call Ms. Fatima Ibrahim to proceed.
Good morning. Thank you, Chair. Is Mr. Nashinzi's camera on? Chair, I can't see him. Mr. Nashinzi, can you
please switch on your camera and unmute?
Thank you. Good morning, sir. Can you please state your full name for the record?
Good morning, the committee. My name is Ramaramunda Baldwin Neshunji.
Thank you, Mr. Nshunji. You have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector, Advocate Enquiry. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. You will now be required to take an oath or to affirm that the evidence you are about to give is truthful. Do you have a preference for either, the oath or affirmation?
It will be an oath. Thank you.
Thank you. May I please ask you to raise your right hand and repeat after me? I swear that the evidence I shall give
I swear that the evidence I shall give
shall be the truth, the whole truth, and nothing but the truth.
shall be the truth, the whole truth, nothing but the truth.
So help me God.
So help me God.
Thank you. Chair, the witness is now duly sworn in.
Thank you, Ms. Ibrahim, and thank you, Mr. Nshunzi. I now recognize Advocate Bauer.
And I note that the time is 10:33.
I was hoping I won't be reminded, but I am reminded. Thank you.
Good morning, Mr. Nshunzi.
Good morning, Advocate Bauer.
Do you have a copy of the affidavit that you deposed to before you?
Correct, I have.
I'm going to ask that the affidavit be flighted onto the screen. It's to be found at bundle D. What can I say? Right. You're currently in the employ at the Public Protector's Office, correct?
Correct.
And you were initially employed in the capacity as the senior manager responsible for security at this office on 10 April 2017.
Correct.
Right. Your qualifications are set out in paragraph 3 of your affidavit. You have a diploma in personnel management, a B.Juris degree, a B.Tech in human resource management, and a master's degree in business leadership. And you had been employed by the South African Post Office as a general manager for several years prior to coming to the Office of the Public Protector, correct?
Correct.
And during the period 2012 to 2017, you were in essence self-employed in the commodities trading business. And correct?
That is correct. Thank you.
Right. Now, you directly reported in your position as security manager in part to the chief executive officer and in part to the public protector.
That is correct. Dotted line to public protector. That is correct.
Right. And in paragraph 6, and you had obtained the job by applying to an advertisement for the post. And after several delays, you got the requisite top secret security clearance, and you were provided with a certificate. Correct?
That is correct.
Your functions of the job is set out in paragraph 6 of your affidavit, which is the functions expected of you. And I don't think that's an issue, and it's listed in the affidavit. Do you agree?
I agree.
Now, for the sake of completeness, you had advised us of 2 issues that had arisen in the course of your employment, which you advise us of commencing from paragraph 9 of your affidavit. And the first in 2018 related to leave irregularities that was found on the IT system, and you were alerted thereof by the public protector and the then acting chief operating officer, CEO, Ms. Motsitsi. Do you recall that?
Yes, I do.
And pursuant to that, you commenced an investigation, and you consulted with, or you consulted, or for purposes of the investigation, you spoke to a number of people in the office, correct?
That is correct.
Right. And then what happened subsequently to that? You communicated as well. Well, let me just put one further proposition to you. You communicated with the head of IT, but you didn't find anything amiss with the system. And then what happened subsequent to that?
Subsequent to me submitting a brief report on the preliminary investigation that I conducted, I was called into the office of the public protector by the acting CEO, who was with the public protector, and they expressed dissatisfaction in the manner in which I handled the security breach on the leave management system. Ironically, because during the preliminary investigation that I conducted, as an investigator, you need to afford an opportunity to people that are linked to that breach, and you will get more information from the people who operated the system. I included those 2 that were suspected that they may have tampered with the leave management system. I think when I explained back that this is the outcome of my discussions with those 2 particular individuals, that's when I saw the expression changing in the office, and they were not happy how I conducted the investigation. In particular, the acting CEO mentioned that I should not have contacted those relevant people. And she felt, and as she communicated with the PP present, she felt that I lacked depth in investigating information security breach. And then I was then told to leave. They will discuss further and contact me. That's what happened. Thank you.
Right. There was then an arrangement that you would attend security training, correct?
Yes, on the days following that, yes, I was called again on the particular date of the 14th February. I was then told that training has been arranged or is being arranged with the state security so that I can be trained on the information security, security breaches, and in general, on security management within the institution. It was agreed that I should come back in the afternoon because the acting CEO will have drafted that letter and I will be given the letter to take to the state security. In the afternoon, of course, they called me again. I was told that this is the letter that, it was a sealed letter. This is the letter that I should take to state security. Consequently, I was shown the letter at the state security. It was addressed to the Director General, requesting him to accommodate me in their training program. And they mentioned in the letter there were quite a number of generic security management issues that were highlighted. From there, I asked what type of training while I was being handed the letter. I was then told, look, we believe that you cannot handle information because of how you investigated the breach, and we would prefer you to be trained. And that's when the issue of suspension came in. It was not like suspension in words, but I was told to buy the PP, to hand over the laptop, the work card, and the keys of the office, and go and stay home until the training is arranged and you start attending training. That was the incident number one. That's how it happened. And obviously, I asked, is this a suspension? Neither of them could confirm. They just say, go home. And then obviously you, from my background, I wouldn't argue with the executive authority. I then left the office, handed over what was supposed to be handed to the accounting officer at the time of the episode, and then I left for home. And the following day, I went to state security. I was referred to a lady who then opened the letter, or the letter has been opened already. I do not know if they sent another version, the other copy electronically to the DG. And then she took me through what has been written. That's when I became aware that these are the things that they want me to be trained on. And unfortunately, at that time, there was no intake. There was no training program running from February. So they were busy soliciting departments to security personnel within their security management structure to attend the security advisors course. And the lady said, we shall keep in touch. And as soon as the number it's sufficient to run a training program, they will contact me. That was on the 15th of February. And that was it. I stayed at home, kept on interacting with the senior people at the state security until around May, when they started to say that the numbers are becoming okay. And then I forwarded all my details, and there was confirmation that the training will begin in July. And I subsequently informed the employer that this is the situation. I think that's when I was told to go back to work. Thank you.
I'm going to put the letter onto the screen just for the sake of completeness, for you to confirm that this was the letter to which you refer. Just go down. Yes, go down. The letter is dated 13th February 2018 from Advocate Busisiwe Mkabane refers, and then it says, we hereby request that SSA recalls Mr. B. Nshunzi for training skills purposes without limiting the scope of training required. More emphasis should be put in the following areas, and then there's a number of areas listed. Go down. And the list is not exhaustive, and the PPSA will appreciate any advice that can be given in respect of the necessary training requirements in its environment. We'll appreciate training resuming as a matter of urgency. Kindly provide us with the name of the person that can liaise and receive Mr. B. Nshunzi for training, skilling and empowerment security matters on 15 February 2018. And the letter is written by the then acting CEO, Ms. Noy Singh Mutsitsi, dated 14 February 2018. Is that correct, Mr. Nshunzi?
Yes, that is the correct. That was shown by the head of training at State Security.
You then complete. You go on the training course in July. You then complete the training course, and when do you return to the office?
When I returned to the office, I resumed my responsibilities, there was no any discussion except that the laptop has been handed back, the office keys, and the card, and I resumed my duties as normal.
And you then indicated that there was a subsequent incident that had then related to documents that had been delivered from the president's office. And in short, you describe what occurs in paragraph 17, that the documents has arrived, you were not alerted to the documentation, and there was a concern that there was a leak of the documentation that had been provided. You had then followed up the trail of the evidence in respect of the documentation, but it was subsequently concluded that there was no leak. And in fact, it was the president's office that had issued a media statement that the documents had been provided, correct? Mr. Nshunzi?
Mr. Nshunzi, are you still there? You're still on the platform, but I can see you frozen. I hope it's not the question that is freezing you. It's off the platform now. Let's just pause a bit and wait for him to rejoin.
Yes, Chair, and I would suggest that he finds a better place. This is the second time he is freezing.
Thank you. We will do that. Okay, I'm told he's joining. We'll wait for him. Welcome, Mr. Nashunzu. Can you hear us?
Thank you so much. Yes, I can hear you now.
I'm going to ask Advocate Bauer to repeat her question.
Sorry, could you put paragraph, affidavit back on screen? We're at paragraph 16. Right. Mr. Nshunji, I then took you to a second incident that you identified that related to documents that had been delivered from the President's office, which had not gone through you. But in essence, what had happened is that the documents were delivered. There was a suspicion that the documents had leaked from the Public Protector's office. You had conducted an investigation and concluded that the leak had not happened at the PP's office, but that had subsequently emerged that effectively the President had issued a media statement about the documents before providing it to the Public Protector's office. Is that correct?
That is correct.
Right. And you then in paragraph 18 say that after that, it appeared your relationship with the Public Protector had been deteriorating. Can you perhaps elaborate on that?
Correct. Part of the activities or responsibilities that I would perform and interact with the PP, I realized that they were no longer required, or you will see via the gesture that things are not the same as they used to be. I started realizing that perhaps it's these two episodes that have already occurred that had an impact, because part of the brief that I got when I got there from the PP was that she was concerned about the information leakages. When I joined, there was a serious leakages that happened. I think it was around CX or any of those matters that were being investigated at that time. And she emphasized the issue of document security and electronic information security, which I should focus on. But then I started realizing that posture for security was diminishing. She would call me from time to time to want to find out what is the security status, and for me to provide her with any reputational risk that may occur, which she may not know because she was focusing on a core responsibility but not security. So I realized that that relationship was not as it used to be. Thank you.
So you say there was an expectation that you had to be the PP's eyes and ears in the office. What did that mean?
Basically, what it means is that in an institution like Public Protector South Africa, their main production or their main products are reports and documents which contain personal information, which contain sensitive information, or they receive classified information from various institutions. So she would need to have an understanding whether the environment is secured in terms of that, and as well as personal security, because I think there were one or two incidents that occurred somewhere where complainants, even here at head office, become violent. And obviously, I need to be alert at all material time. And then, like I said, part of my main responsibility will be to do security and risk assessment of the entire institution. Obviously, when you do so, you need to interact with personnel in the institution, because those are the people that are working, those are the people that could create those breaches, and they can advise you where the problems are while you conduct security assessment. So she would want me to ensure that that happens, and I constantly provide her with feedback regarding the security environment of the institution. And it is not limited to security only. You need to ensure that the people understand they conform, because if they are dissatisfied, conformance to the rules and regulation becomes difficult. That's why it is written as PPA eyes and ears in the office, is to ensure it was mainly to illustrate that you need to ensure that there is harmony in terms of compliance, in terms of security of information that the institution hold. And obviously you do that by communicating with people. Thank you.
You then indicated in paragraph 20 that you received a telephone call from Mr. Fraser, who was then the Director General at the SSA. Can you elaborate on what then transpired?
Yes, he called me one evening and said I should avail myself of the state security establishment. And then I drove, it was around 8 o'clock in the evening. I went there. I waited for him because he had several meetings. And then when he approached me, he said, Mr. Baldwin, I've got a concern raised by the PP. I was shocked to hear that there was a concern which she could not tell me, perhaps because of that trust relationship. I do not know. And then he told me that the PP is not happy with the necessary support that I should provide her in managing the institution. And we had discussion with him. I said, but I do not know what her concern is about, because I thought she was happy with my performance, but I was told that I was not doing enough to ensure that there is a necessary support provided to her, and I do not know. He did not specifically. I tried to persuade him to give me which specific area am I not supporting the PP. But he just said, go back and pull your socks and work hard, demonstrate to her that you are there to support her. And that was the discussion that took place that night. I couldn't go ahead and say, I heard that you have interacted with the DG, but you know, I did what Mr. Fraser said, that you need to go beyond your call of duty and demonstrate to your executive authority that you are on top of everything. Thank you.
Now you would then ask, you indicated that you had known Mr. Fraser from a previous context in which you had dealt in commodities during that period. And you then recalled meeting him at the office of the Public Protector when he attended, accompanied by Ramabulana and Mr. Mahindra Moodley. Can you tell us how the details of that meeting?
Like I've indicated, I was not part to that meeting. I was doing my daily routine work at the reception when I saw them coming out of the building. Obviously, because I was working with them on case management system and other IT security systems that we needed to employ here at the PPSA. I greeted them and walked them out to their vehicles, but I was not part to the meeting that they had with the Public Protector.
And tell me, is Mr. Ramabulana known to you?
Yes, I know James Ramabulana. And
how do you know him?
Well, I know him while we were still at tertiary at the university, and I knew him again when I met him again when I became a security manager. That he works at the state security, and he does information analysis. That's how I know him, and I know him from the youth structures then, or the university youth structures then. Thank you.
And Mr. Moodley, is he known to you?
Yes, indeed, I know Mr. Moodley. I met Mr. Moodley after we requested state security to assist us in developing case management system and other related information security systems. So he was the team leader of the experts, IT experts at State Security who would assist us after giving them the business requirements, and we will interact with them. But he was the overall leader in ensuring that we have a case management system and those relevant security systems. Thank you.
In fact, Mr. Nashunzi, I'm going to just take you out of line and take you to paragraph 33 of your affidavit, where you, my apologies for doing that, paragraph 33, where you indicate that SSA's assistance had been sought for the development of a case management system at the Public Protector's Office. This was because it had used the manual case management system and the organization was requiring an electronic case management system, correct?
Yes, correct.
And the SSA then approached to assist in devising a system for the Public Protector's Office, correct?
Correct.
And in fact, you say in paragraph 34 that you and Mr. Niels van der Merwe and others from the PP's office met with persons from the SSA's office, including Mr. Maudley, for purposes of this process. Is that correct?
That's correct. It was quite a sizable delegation. Even the acting CEO at the time, because he assumed that after, she was part and parcel of that delegation, and Mr. Futana Tevele. I led a delegation of about 5 senior personnel from PPSA to State Security. Thank you.
And one of the people involved in that presentation, was that Mr. Maudley?
Yes, Mr. Maudley would be, yes, he was the leader of the project. So he was the one who would provide various alternatives and efficient methods of building up a system that will be integrated with other systems, because we did not have a backbone system. We were operating on various systems that you create on the computer, but not a real platform where all other ancillary or secondary systems will be connected to. So we felt that the case management system will be used as a backbone where you can hook up SAP and other related systems for other functions within the institution.
And you describe him in your affidavit as an expert in IT and some whiz kid in that field. Is that how you considered him?
Yes, with my formal training in the systems and my limited understanding of system development, as I had coordinated that in my past working environment of facilitating development of systems, I found him to be an expert in IT. And this would have helped us, as you would know, that CETA is the agent for the state institutions in terms of procurement of systems and management of those systems. So obviously, state security as the custodian of the state information in the country, it would have helped us because there are a lot of issues like your license agreements with Microsoft. We wanted to to focus on that, so that because they had bargaining power, because they have several systems that were running. I think at that time they were finalizing the Home Affairs or SARS system. So we needed to piggyback on their ability to bring on board the OEMs of those particular softwares and hardware. And I found him to be extremely good in the field of IT. Thank you.
But you don't know what happened to this project because you had been suspended and eventually you had left the position of security, correct?
Yes. When I came back from the second episode, I was told by those that those that were the members of the team that were working with the state security that the organization has decided not to pursue that because the state security came with a high bill of the system if they were to develop it themselves. Ironically, I did not understand because this was not done at lower level. It was done at strategic level. The public protector was fully aware of this. And as much as we had only 6 million to spend on procurement of this CMS per year, the understanding at top level meeting was that we shall pay as the development happens, because it will have happened over the period of 3 to 4 years, to have a flagship system. So that 6 million will be utilized to pay for those developmental costs that are associated with the system. So unfortunately, I couldn't take it more further. Then we started exploiting other systems that are used by global ombudsmen elsewhere, where they will come on pro bono basis and help us because we did not have sufficient resources, as the money was a problem in terms of system development. Thank you.
Right. If I then go back to paragraph 22 of your affidavit, I'm sorry I took you out of sequence. You returned after your first period. You came back from the training in about the course in December 2018, and it was your job to obtain the security clearances for people at the PP's office. Is that correct?
Correct.
And the issue of the acting CEO, Mr. Vusi Mashlangu's security clearance arose, correct?
Correct.
And effectively, the SSA did not want to issue a top secret security clearance for him.
Correct.
Right. And to the best, you say to the best of your recollection, this related to charges emanating from his previous employment. Is that what you recall? Right. What was, so you were advised by SSA that they were not going to issue it. What then transpired thereafter?
Yes, I requested a meeting with the heads of what we call VA10, which is Vetting and Advisory Services Division at State Security. I had met with the 3 key personnel responsible for vetting process, and trying to expedite the issuance of this particular certificate, because indeed it has delayed, and it was impacting on the institution because Mr. Mahlangu was a CEO, and obviously for him to be confirmed, his probation period to be confirmed, he told me that the clearance certificate was necessary. However, in the meeting that I had with those guys before I eventually went to collect the written letter, because I requested them to put it in writing to the public protector so that she knows that there is sufficient effort that is being put to make sure that we expedite the issuance of the certificate. They told me that there could be minor issues that could be eliminated by representation. I think during his testimony, he indicated that he made several attempts to make representation on smaller issues that could have been that could have contributed to the delay. However, the main issue that the state security indicated was that there seems to be, when they were doing vetting, there seems to be charges that were outstanding or that were on the roll, and there were few matters at the court, I think it was labor court, which they will be reluctant to issue that until that matter is clarified. As soon as that happens, Mr. Mahlangu should communicate with me so that they become aware and they will expedite the finalization of that process. And I think that has been communicated even on the letter. So that's what happened, and we couldn't get that top secret clearance pending the finalization of his former employer issues. Thank you.
And how did Mr. Mahlangu take to that?
I will use my personal observation. He did not take it well. He did not take it well at all. Of course, I've got top clearance. There's certain information that I cannot discuss here. He didn't. The fact of the matter, he did not take it on because he attempted to. In fact, he called some of the people that he knew at the state security, and I was called by those divisional heads, and I handled the matter the way I handled it, and alerted the PP. But subsequent to that happening, he started to somewhat